Joining us now is legal expert Mpumelelo Zikalala to talk to us about this. Very good evening to you and thank you so much for your time. So the law says that lifers, that is inmates serving life sentences, are not automatically entitled to parole, but this needs the approval of the minister. Let's talk about the process then that's likely to unfold now.
Good evening to you, Mangata, and also to the viewers. You have to look at the Correctional Services Act, which is very prescriptive as to what is the timeline which is applicable. Now, it says life imprisonment, the minimum period is 25 years. So it baffles me a bit as to how did this application come through at year 21 when there are still 4 years that are still outstanding before a person can even start to apply? Why waste the time of all the entities that are there, the Parole Board, and even the time of the minister submitting an application in which you know very well is not going to suffice? Because when you look at Section 73(5) of the actual Act, the Correctional Services Act, is very prescriptive as to what ought to happen and what not to happen. But what it has done, I think it shows again the inefficiencies of this process. The non-looking or non-focus, or the process is not centric on the victims to say, at the end of the day, it must be about the victim. And if you're going to go properly interrogate what the victim is looking for, you may end up with a flawed process which does not deliver the justice that which you are looking for.
So in light of that then, speak to us about the victim, because I'm interested, right? Because tonight, Leigh Matthews' father says that he's not rehabilitated at all. And I do wish that the law will not just tick a box, but in fact will actually take all the matters into consideration here. You heard the questions that he still has. To what extent do those matter when it comes to the stage?
They must matter a whole lot, but unfortunately, the way in which it has been interpreted and the main in which our courts have interpreted this part of Act, it seems as if it's a tick-box exercise. Let me cite another controversial case, the one of Wanus Yalus. At the end of the day, you had the Constitutional Court saying that all the boxes have been ticked, make sure that you release this individual, and not looking at the actual victim itself and the type and the genuine remorseness of the person that is involved. What happened a few months after that? You have a person doing an interview in a foreign country saying that they would do it again if they needed to. So meaning they knew and understood very well the process, they knew and understood the loopholes that are there, and they were exercising it. Now, this law should not have been created to make sure that prisoners are getting an alternative access to being released on a separate basis. When a person is sitting in that courtroom and they are being told that the person that killed their loved ones is going to spend the rest of their life in prison, that is what they expect. If that's going to change, then don't lie to the victims and to the sufferers. Tell them this person is going to stay a number of years. After that, they're going to be eligible for parole. This is what's going to be looked at. But if even if you put that aside, the whole process was made so that at the end of the day, there's some type of reconciliation, there's some type of justice which is being served, there's some type of closure which is received. If all those things are not there, then it means anyone who's released is simply released based on a technicality and is not the authenticness of the intention of this act which is being followed, and which is why we would find situations such as this one. On this one, my humble submission would be it should have been rejected at the start to say the number of years in which you're supposed to serve, you have not reached them yet, go back and then we'll consider your application when you have reached that stage.
So in light of that then, can we see, and I'm glad you mentioned the case of Yanush because I was going to go there to say that there was that backing and forthing with the minister as well. So is it a possibility in this matter?
It may be a possibility. If the minister is going to come back and say, no, I'm not releasing you, they may take the decision of the minister to court for a review to say, we want to review and check what the minister has utilized. Is it a decision which is taken based on legality, rationality, and procedural fairness? And if the answer to that is yes, then they would be released. But if the answer to that is no, when there are certain regulatory flaws or non-compliances that have taken place, then the minister as well and then the right to say, let's stop this, we're not going to continue with it. But I think the bigger question in this one, especially for the 400 parliamentarians or the legislature that sit every day and they create these laws on our behalf, look at whether the Correctional Services Act is rendering the type of service in which South Africans are looking for. Or alternatively put, is it delivering the justice in which it's been looked for? If it's not, then tell individuals the truth. If a person is not going to spend life in jail, you tell them on the day a sentence has been issued, you're not going to spend life in jail. It's going to be a number of years, then going to be eligible for parole. Even then, let's go a step further and interrogate. What does the parole board actually look for? Do they even consider the instances of the victim when it comes to this? Do they consider the no's which would get from those victims? If they don't, then why are they there if they're not going to apply their minds? I think the bigger question should be, let's look at the intention of this act. What is it that is supposed to mean? And maybe even go a step further and say, as the parole board, these are the steps that you must make sure that they are there before you even consider the application.
And it's also quite pertinent because I remember in May when when Parliament, the committee was seized with this particular matter, also discussing the law in and itself as to, some of the issues, how far does it, really take the victims into consideration, etc. But then when you look at all of this, and if they were to re-look at the law, it also, one would say, would minimize room for error. Because we've seen, even in the case of that, the woman from the Western Cape, who was worried that the killer, the husband who killed her children, was going to be released.
Definitely. And then it's just to say, let's interrogate and look at what the loopholes are there. Let's look what the court has stated so that we're able to deal with the matter. It's a solution that can be found. And the way of finding it is to simply say, let's go back to the drawing table, draft new legislation which is going to take care or take into account the views of the individuals or members of the public, and then we'll take it from there.
It's going to be interesting to see then even, what Parliament does with all of this information. I appreciate your time. That was legal expert Mpumelelo Zikalala.